Hello viewers, and welcome to part 3, which is the final part of our video series entitled Trusts and Trust Administration. My name is Richard Land. I'm an attorney and a member of the Danbury, Connecticut law firm known as Chipman, Mizuko, Emerson. Now let's talk about some problems a trustee can get into when entering into contracts. This is another feature of being a trustee that trustees often do not fully appreciate. Before enactment of the Uniform Trust Code, when a trustee would enter into a contract, he personally would be entering into the contract, not the trust. This is not the same thing as when a corporation enters into a contract. No, the trust is not an entity for this purpose like a corporation. Rather, the trustee personally would be the party to the contract. So if the trustee promised to pay $50,000 to XYZ engineers for a subdivision analysis for the trust real estate, and there's no cash in the trust to pay the fee, the trustee would have personal exposure to pay the fee to the engineers. In other words, even if the subdivision is not approved, and if the trust is unable to raise the cash to pay the fee because the property could not be sold, the trustee would be personally responsible for the payment. In that case, if the expense were a reasonable and proper expense for the trustee might be entitled to reimbursement from the trust. All that's to suggest that the trustee needs to be careful to limit his exposure when entering into contracts. The trustee might do so by making certain that the related costs are reasonable and proper for the trust. One good way to do that would be for the trustee to ask for court approval. Or the trustee may include contractual provisions which will eliminate or reduce personal exposure. Or, as part of the transaction, the trustee may ask trust beneficiaries to hold him harmless for such costs or claims. The Uniform Trust Code makes a technical change so that now, when a trustee enters into an agreement in his capacity as trustee, he is not personally liable on a contract properly entered into in the trustee's fiduciary capacity if the trustee discloses in the contract that he is acting in his fiduciary capacity. That's not as good as it might sound because a claim can nevertheless be asserted against the trustee in his fiduciary capacity. The trustee may be liable one way or the other, either directly to the engineers who want the $50,000 fee for the subdivision analysis, or to the beneficiaries when they complain if the trustee ultimately pays the fee from the trust. A trustee may be personally responsible for tort claims. Now, what's a tort? Generally speaking, a tort claim is any claim other than a claim based on contract. Usually, when we talk about torts, we're talking about negligence claims, but they also include intentional acts such as fraud or assault and battery or trespass. Trustees should keep in mind that trusts are not negligent, but trustees may be. A trust will not be liable for a trustee's negligence, but the trustee may be personally liable. So, if the trust owns rental real property which is not properly maintained as a result of the trustee's negligence, the trustee may be held personally responsible without right of reimbursement from the trust. One example we dealt with involved a farm and a trust. Farms involve some special risks. In this case, the farm animals included a herd of cows and 1 or 2 bulls. When an appraiser stepped onto the property at the trustee's invitation to take a look at the property, he was charged by one of the bulls. Luckily, no one was hurt, but these are the types of unusual things a trustee should be thinking about. And of course, there are always the more common risks. The trustee should take steps to limit exposure by identifying the risks and dealing with them in a prudent way. And adequate insurance is always something to consider. The trustee's exposure to personal liability is important when talking about environmental contamination. The Superfund Law, or the Comprehensive Environmental Response, Compensation, and Liability Act of 1980, or CERCLA, imposes strict liability on property owners for certain polluting acts or conditions. By strict liability, we mean that if you are the owner, you may be held personally liable whether or not you did anything to contribute to the polluting condition. Is a trustee an owner? Is a trust beneficiary an owner? In general, the answer is yes. So as CERCLA was originally enacted, it created a big problem for trustees. Later, as the result of the efforts of the banking lobby, a trustee's liability was limited under certain circumstances where the trustee was innocent of certain types of malfeasance or misfeasance. But the protection only applies when the trustee is acting exclusively as a trustee. If the trustee is both a beneficiary and a trustee, the limit on liability may be lost. In any event, it makes sense for a trustee to try to fit within one of the CERCLA defenses, the most important of which is the innocent landowner's defense. The defense will apply if the polluting condition already existed when the trustee receives the property was received by inheritance or bequest, or if the trustee had no reason to know that the condition existed, the trustee did not contribute to the condition before receiving the property in a manner that would otherwise make the trustee liable, and the contamination was caused by a third party with no contractual relationship to the trustee. In that case, a trustee can count on the liability being limited to the value of the trust estate unless the trustee's own actions contribute to the contamination, and the trustee will not be held personally responsible if the trustee takes appropriate action to remediate. Another potential problem a trustee may face is the prospect of making distributions to beneficiaries before all trust obligations have been satisfied. For example, in one situation we were asked to deal with, the trustee was responsible for a trust having a value of approximately $1 million. The trustee didn't realize that he had a responsibility to pay an estate tax from the trust assets and that the estate tax had a value of approximately $400,000. The trustee distributed all the trust assets to the beneficiaries without paying the $400,000 tax obligation. The trustee ultimately had to pay the estate tax obligation to the IRS out of his own pocket and asked the beneficiaries to return a large part of what had been distributed. Some beneficiaries were able to do so, and some were not. The point is that before a trustee makes such distributions, he needs to be as certain as possible that there will be no surprise claims on the trust assets. The trustee should try to reduce the risk as much as possible, either by obtaining a court decree which approves the distributions, that would be part of an accounting proceeding, or by obtaining refunding agreements from each beneficiary. We have been discussing the types of issues a trustee must deal with. When you take the time to think about it, the trustee provides an important and challenging service and at significant personal risk, and the trustee deserves to be compensated for the services provided. Quite a few years ago, we collected all the information we could on what banks and trust companies would charge for services as trustee. This table is representative of what we found at the time. Keep in mind that the fees in this table represent annual fees. The numbers you see here should be considered ballpark numbers, representative but not really the fees of any particular bank or trust company. From information we can gather today, we believe that this continues to be fairly representative. Keep in mind that banks and trust companies will be performing all the various functions of a trustee in-house, including the investment functions. An individual trustee will be much more likely to delegate the investment responsibilities to a qualified investment advisor. In that case, the trustee's fee should be reduced to reflect the individual trustee's reduced responsibilities. That's the end of our screencast on trusts and trust administration. I hope you have learned something from this presentation, and if you have any questions, we would be pleased to have the opportunity to answer them. Thank you for viewing.